Another law that we want to be familiar with as we talk about gender discrimination and gender laws is the Pregnancy Discrimination Act. Interesting. Title VII prohibits discrimination because of what? Or based on what? Gender or sex, okay? Now, the Supreme Court held that pregnancy discrimination was not covered by Title VII. Okay. So somebody files a lawsuit under Title VII, says they've been discriminated against because they were pregnant. Case goes up to the Supreme Court, and the Supreme Court says, sorry, Title VII doesn't address pregnancy. Now, that really, by the way, and you read these cases sometimes and you go, why do I have to read these cases? And some of them are really exciting, some of them are really boring. You go, why? The truth of the matter is a lot of our laws come out of these cases that Congress says we don't like what the Supreme Court did. It's a balance of powers. It's how you got Lilly Ledbetter, okay? Lilly Ledbetter, they ruled against her. Congress says, we'll take care of that. We'll get a law. Same thing with the Pregnancy Discrimination Act. Supreme Court comes along and says, Title VII doesn't apply to pregnancy. Congress says, you know what? We can take care of that. We'll pass the Pregnancy Discrimination Act. And so they do. They passed the Pregnancy Discrimination Act in 1978. Okay? And now, basically, that act didn't do a whole lot. I mean, big strides for women. But as far as language and stuff, it just included, the major part of it was, it amended the definition, quote, because of sex, under Title VII, to include pregnancy and related conditions. Okay? So the Pregnancy Discrimination Act says, Title VII, where it says discrimination, you can't discriminate because of sex, that really also means pregnancy. All right. Give me an example of discrimination for pregnancy reasons that might be a violation of the Pregnancy Discrimination Act. Because now you have this law that says you can't discriminate against pregnancy or related conditions. What might be an example? Lisa?
If I told my manager that I was pregnant and they fired me for it.
Yeah. Firing somebody because they found out you're pregnant. Okay? All right? So firing a woman because she's pregnant. What else?
Refusing to hire someone.
Refusing to hire, yeah, bro. Refusing to hire a woman because she's pregnant. Okay? What else? Changing jobs or requiring an employee where you don't hire them, and you don't fail to, I mean, they're already your employee, so it's not that you failed to hire them. You don't fire them, you just make them have a different job. Okay? Give you an example. Had a situation where, and we ended up settling, and it didn't cost us a whole lot, but cost us some several years ago, a client of mine. The young lady worked at a restaurant making biscuits and comes in and tells her employer that she's pregnant. And evidently, with regard to the making of biscuits, there was a lot of lifting, a lot of heavy lifting involved, a lot of standing on the feet, not as many breaks. It was just evidently in this particular industry, it was harder work than other work. Didn't fire her. In an effort to help her out, he simply moved her to the cash register and also agreed that she could have a stool to sit on so that she could be sitting down. She didn't want that, and she filed a charge of discrimination, and we ended up working with them. But quite frankly, she would have had it gone all the way to court, she would have been right. Okay? You cannot have somebody change jobs if they're pregnant. All right? Along with that, also an example of pregnancy discrimination is what we call fetal protection policies. Fetal, F-E-T-A-L, protection policies. What would be an example of a fetal protection policy? Or what might be a fetal protection policy? Not necessarily an example, but what are we talking about when we say fetal protection policies? Melissa?
Keep the lady from having a miscarriage. If she was having to lift, you can't make her lift those. If it's 50-pound bags of flour, you're going to have to come up with another solution, have somebody else help, or have the bags already where she can get the flour out. You're going to have to come up with another.
Okay, right. But you can't, you're absolutely right. We can't treat her one way or the other, even if the restaurant or the employer thinks it is for the protection of the fetus. Okay? Where you see some of these cases is in chemical situations, all right? So that pregnant women shouldn't work around certain chemicals, all right? Not, I guess that's sexist, but it really isn't, because there are some areas where chemicals, and doctors will tell you, chemicals will endanger, a woman who works around these particular chemicals will endanger the fetus, all right? There are cases out there where an employer, with the fetus in mind, has tried to tell the woman she can't work in this particular area or in this particular industry until after she's given birth. Courts say pregnancy discrimination, okay? Because it's discrimination based on sex, even if you're trying to protect the fetus. So those are examples of pregnancy discrimination. Terminating a pregnant woman for tardiness, okay? Why might a pregnant woman be tardy? Morning sickness, right? Okay? Can't treat her different because of that. If there's an attitude or energy level change, you're more hormonal than whatever. First of all, you don't want to say that, but secondly, you don't want to act upon that, okay? Because with pregnant women, that may be, and truly even with non-pregnant women, but certainly may be discrimination and a violation of the Pregnancy Discrimination Act. And I sound like a voice of experience, and there's a reason for that. Okay? All right. Also, providing less coverage for spouses of male employees for pregnancy than you might provide for other medical conditions of female employees. Let me tell you what I'm talking about there, okay? Providing less coverage or for medical conditions. Policies were written for a while that said if you're out because of, if you have back surgery, we'll cover 80%, 20% deductible, okay? Basically, these policies said we'll cover everything at 80%. However, if you're pregnant, we'll cover 10% and you're responsible for the other 90%, okay? See what I'm saying? That would be a discriminatory policy. All right. And somebody asked me about, and we'll probably talk about that with regard to religious discrimination, about Obamacare, the new Health Care Act 2014. We'll talk about that a little bit when we talk about religious discrimination because of the idea of birth control and contraceptives and get into that. But that may very well be a violation of the Pregnancy Act, depending upon how it's done, okay? Depending upon the language of the policy and what it compares it to. Okay. Any questions on the Pregnancy Discrimination Act? Yeah, Jackie.
I feel like it'd be a bit of a stretch to prove, but if you could show that you weren't hired for a particular position because the person interviewing you decided that you were of childbearing age and time period in your life, would that fall under pregnancy discrimination?
Yeah, it would. Not so much because of that, but probably because of your gender. I mean, you know, and somebody asked with regard to, you know, I think had a professor that said, hey, you don't wear certain jewelry or whatever because you might be asked about family, etc. First of all, in the interview process, they probably shouldn't ask you if you're married or about your children anyway. Okay, and there's some argument that you wear a wedding ring, because if you wear a wedding ring, what does that, if you're female, what does that show? I mean, it shows the same. Okay, let's back up. It's been a long day. What's it show if you wear a wedding ring? That you're married. But what does it show about a woman that may be taken with less kindly to, if you will, than a male?
That you might be family planning.
That you might be family planning, or that you might even have a family. All right? And so there are those who would say you don't wear jewelry to an interview because you don't want to give off, you know, I want to say jewelry, certain jewelry, you know, because you don't want to give off the impression. I'm not sure, and maybe that's because of where I've been and the interviews that we did, and we weren't discriminatory, but, you know, that can go both ways. Because if you're not wearing a wedding ring, that can show certain things that some employers may not like as well, okay? That you're not stable or whatever. But certainly employers shouldn't be asking you that question. But yeah, if they don't hire you, and you're right, it'd be horrible to prove. But if they said, yeah, I didn't hire her because she might be pregnant someday, that will be discrimination. Probably not pregnancy, probably just plain old gender discrimination. Okay? All right. Let's talk then about sexual harassment. Get away from the Pregnancy Discrimination Act. I think you probably understand that. Let's talk about sexual harassment. Okay. Here is the Equal Employment Opportunity Commission's definition. I'll read it and we'll give it back to you. Unwelcome sexual advances. So unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature that has the effect of creating a hostile or offensive working environment. So sexual harassment, according to the EEOC, is unwelcome advances, requests for favors, and other verbal or physical conduct of a sexual nature that has the effect of creating a hostile or offensive environment. Now, the EEOC goes on, I've kind of shortened the EEOC's definition. The EEOC's definition also includes this phrase, without regard to whether or not it's directly tied to the grant or denial of an economic condition, okay? Which is what we call quid pro quo, and I'll come back and explain that. But basically, for the class purposes, what I want you to know is harassment, unwelcome sexual advances, requests for sexual favors, other verbal or physical conduct of a sexual nature that has the effect of creating a hostile environment. Okay? Now, that can include basing employment decisions on an employee accepting or rejecting requests for sexual favors. And that's what we call quid pro quo. Okay. Give me an example of quid pro quo. Excuse me. Or maybe you feel better if I give one. Were you going to give one?
I can.
Okay.
If you have sex with me, then you get a raise.
Yeah, absolutely. Okay? Go on this business trip with me, and you'll get a raise. The flip-flop of that can also be true. If you don't have sex with me, you're going to be terminated. Okay? That's what we call quid pro quo. Really the idea of, I do something for you, you do something for me. Okay? Now, that's the quid pro quo portion of it. If there is not a quid pro quo, we generally refer to that just as a hostile environment. Okay? The mere unwanted sexual advances The request for sexual favors, the unwanted verbal or physical conduct, whether tied to any exchange or grant of economic condition or other favor with it, is simply a hostile environment. So that if you don't have that going on, if you don't have that quid pro quo, it can still create a hostile environment. Now, back up to the idea of quid pro quo. Could be a pay decrease. Could be a pay decrease. Could be a demotion. Could be tougher work. Could be a new office where you're in a closet, whereas before you had a corner office. Okay. Those are all the threats. As far as the rewards go, could be a pay increase. Could be a promotion. Could be an easier job. Sleep with me and you can come to work, but you don't have to do anything. Type of thing. Okay? Hostile environment, on the other hand, doesn't involve those same favors, but it creates or interferes with the employee's performance or creates a hostile working environment. Okay. Now, from the standpoint of unwelcome conduct, and that's really what you're talking about, remember that definition is unwelcome sexual advances. When you're looking at unwelcome conduct, when you're looking at this hostile environment, you are looking from the impact of sexual harassment, not the intent. What do I mean by that? Any ideas? Jackie?
Well, it's like if you have a work environment where certain employees think that they're just joking around or just teasing, or they don't realize that they're really bothering someone or affecting someone, but the impact on that person that's being harassed is that it's upsetting or interfering with their work or something that's...
Yeah, you basically, as Jackie says, you have a situation where people, maybe that's just the atmosphere. They just joke around. They just say, oh, that's the good old boys doing whatever they do. Or that's just Bill. That's the way Bill is. And Bill may not be intending anything, but that's not the standard. You look at the impact, all right? You look at the impact. If the behavior is unwelcome, it may be considered sexual harassment even if the harasser didn't intend it that way. Okay? So you look at the impact, not the intent. Unwelcome is determined by the recipient, not the person engaging in the behavior. Okay? Now, having said that, that doesn't mean that anybody who gets offended over every little thing automatically has a sexual harassment complaint. It is a reasonable person standard. And would a reasonable person find the conduct objectionable? I'm going to show you, hopefully show you a couple of examples later on of where sexual harassment has gotten into some other areas, and we'll look at a couple of examples. I won't say more than that right now, but it's unreasonable conduct from the reasonable person's point of view. Okay? Now, examples, give me some examples of verbal harassment. Or maybe I should do this. Slurs will be general. I won't give you specific examples. We'll do it that way. Slurs of a sexual nature. Okay. Name calling. Whistling. These come from real cases, by the way. Barking. Grunting or growling. Okay. And by the way, it usually has to be, and we may talk about that in just a second. Now, let's go ahead and talk about it now. It generally has to be pervasive, okay? And you don't want to do it, but just because you grunt one time or growl one time or bark or whistle one time doesn't mean that that rises to the level of sexual harassment, okay? Doesn't get into a hostile environment. One time just depends upon the nature of it, all right? Well, that's what we talk about, the verbal side. Physical harassment is exactly what it is, assault. Okay. Impeding or blocking movement. Okay. Interference with normal work or movement. You've seen the ones on your TV shows or whatever where the secretary's going to the copier machine and the guy interferes with her progress. Okay, that's what we're talking about there. Licking of lips. I had a couple of cases. You just read. I don't know. I may put on a deposition for you to read a couple of some of these, and you just go, really, you know, you gotta wonder, you know, even from the guy's standpoint, where didn't you pick this up somewhere that you're going to get sued for this? You know, I mean, some of this stuff that we see is pretty interesting. Okay, adjusting clothing, you may see that. And the importance of this is also be careful when you're in your work environments. Guys, if you see a woman's button that needs to be adjusted, you don't adjust it. You may tell her about it or whatever, but you just don't start saying, oh, let me help you with that, okay? Not a good thing to do, okay? So that can be an example of physical harassment. Then you can have, and we'll look at a couple of examples where it probably has gone maybe beyond, but visual harassment as well, okay? Having derogatory posters, cartoons, drawings of a sexual nature. I know of a couple cases going on right now where, you know, the employer may have had his computer facing out to where people could see it and would have pornography on it or cartoons on it of a sexual nature, and you just kind of wonder again, why? Don't you get this? And maybe I have done enough of teaching this class and done enough employment law. I go, gosh, how stupid can you be? You're going to get sued. But they do, and then they get sued. So, but those are all examples that constitute sexual harassment. All right. A couple of things about liability. Under federal law, the individual may not be liable. The individual doing the harassment may not be liable, while his company may be liable. Okay. Under state law, an individual frequently can be liable. Now, don't get me wrong. If you have a male supervisor who has sexually assaulted a female, he's going to be liable. Okay? But if you have a situation where the supervisor just makes unwanted sexual comments, that supervisor may not, under the law, be able to be sued. And the reason for that is Title VII deals with employers, all right? And may not define employers as individuals or as supervisors. The employer at Kraft is who? Kraft. It may not be the particular supervisor. Whereas a lot of state laws, the employer is defined broad enough so that it is not only Kraft, to pick on them, okay, but any supervisor or person who oversees the employment of somebody else. All right. Now, a couple things about employer-supervisor liability, because these are pretty I say fairly recent cases. They've been out for 3 or 4 years, but they're pretty important to know. Generally, an employer is liable whether the harassment occurs by a coworker, a customer, or a third party if the employer knew or should have known of the problem and failed to respond quickly enough. All right? Give that to you again. Generally, an employer is liable whether the harassment occurred by a coworker, customer, or third party if the employer knew or should have known of the problem but didn't respond quickly enough. Now, let me stop here because I had a question on this, and I thought it was a great question. Harassment, by the way, you don't have to be the one who is harassed to file the charge. Okay? If you're offended by it. So, for instance, let's say Lisa's the one being harassed, but Day sees that harassment, and Day can file a charge. Okay? And that can prompt it. Now, somebody asked me, which was a good question, and let's go back to my example with Lisa and Day. So if Lisa doesn't report it, can she be fired? And the answer to that question is yes. Okay? If you have a policy that says you can be fired or that requires you to report it. Now, having said that, if you come to me back in the days when I was in private practice, I would tell you don't do it. Okay? Because I think it's dangerous. But I wouldn't have any problem, and in fact we may have done this recently with one of our employees, given them a written or a verbal warning and put it in their file because they didn't report it, and we found out about it. Okay? Probably wouldn't want to terminate, but that's how serious that a lot of companies take that. And so an employee that doesn't report it, even if they're being harassed, can be terminated. Now, if they weren't offended by it, that's one thing. Okay? But if they were offended by it or knew what the policy was and knew that an employer or a manager was violating that policy, then it could be. All right. Employer liability for when you have what is called a tangible employment action. Let's talk about that, because it's a little bit different if it's a tangible employment action versus no tangible employment action. And to get there, let's first define what is a tangible employment action. A tangible employment action is simply a concrete action that you can see. Person gets demoted, person gets pay decrease, okay, person gets fired. Those are tangible employment actions. Where the supervisor's harassment results in a tangible employment action, the employer is going to be held liable. No doubt about it. So, excuse me. If you've got a supervisor and that supervisor fires somebody, you have a tangible employment action and the employer is going to be liable. If you have, on the other hand, a supervisor who is simply engaging in the behavior and doesn't have a tangible, there is no tangible employment. Again, no firing, no pay decrease, nothing like that. The employer may be able to raise some kind of a defense by showing that it exercised reasonable care to prevent and correct the sexual harassment, and that the employee failed to take advantage of it. Okay? So if you've got a supervisor situation in a tangible employment action, employer's going to be liable for that supervisor's behavior, if the courts find there was discrimination. If you have a non-tangible, you don't have any tangible employment, you just have the harassment going on, the employer may not be as liable if the employer can show, look, we tried to prevent sexual harassment. Now, how can an employer show that? Have a policy against it. Okay? We don't want sexual harassment. Here's what sexual harassment is. If you do this, you can be fired. If you see this, come and report it. We don't tolerate it, et cetera, et cetera, et cetera. Okay? That's having a policy. Then, once you have that policy, if the employer can show that the plaintiff didn't take advantage of it, okay, then the employer may not be liable. This situation frequently comes up when the employee gets fired, has nothing to do with sexual harassment, just gets fired, and on the way out the door says, oh, by the way, I've been sexually harassed and I want to make a claim, and files a charge of discrimination. And the employer comes back and says, well, when were you sexually harassed? And the employee says, I've been sexually harassed for the last 6 years. Okay? Well, we had a policy and you didn't do anything about it. Employer may not be liable where there's no tangible employment. Okay? Now, were they fired? Yes, but not connected to the sexual harassment. Okay? All right. Missouri may not recognize that defense for what that's worth. Part of the problem with these sexual harassment cases is the jury awards can get pretty high. The jury awards can get pretty high. And frequently what happens, and I don't know if we talked about it in here or not, frequently what happens with these jury trials that you read about, or these jury verdicts that you read about, and you scratch your head and you go, how does that happen? What frequently happens is somebody ticked off the jury. All right? The McDonald's coffee case. When people hear about the McDonald's hot coffee case, they go, oh my gosh, that, you know what I'm talking about? Yes, most of you. They go, the lady spilled hot coffee going through the drive-through, and as a result, she ended up with a pretty large verdict in that case. All right? What you don't hear is that she really tried to settle it early on, okay, well before it went to trial. McDonald's was having nothing to that. What you also don't hear is that somebody during that case ticked off the jury, okay, by, as I recall from reading, and I may have this a little mixed up, but as I recall from reading, say, we know our coffee's hot, we know it's could burn people, but we don't care about that. You know, said something that probably didn't mean it that way. That's how it came off, and the jury said, well, let us teach you how you should care, okay? And then they give this verdict. Example happened in Missouri, case of Kimsey versus Walmart. I don't know if I put it in your material or not, don't recall. But a verdict for $5 million plus in a sexual harassment case. But the reason that verdict got so high is because the defense counsel for Walmart got into the face of the victim while she was testifying and said, and I won't do it, but held up his middle finger and said, what does this mean? And then proceeded to tell her what it means by using the words F, U over and over for like 3 or 4 or 5 times in her face. It means, and you know that, and kind of going crazy, okay? As a result, what do you think the jury did? You know, gave a huge verdict. Now, it eventually went up to the Court of Appeals, and the Court of Appeals said, hey, we're taking it way back down. I think they took that $5 million maybe to $500,000. Took it way down. But the bottom line is still a lot. So when you get in management, you want to avoid, or human resources or whatever, you want to avoid all of that sexual harassment. You want to nip it in the bud. You want to take care of it at the very beginning and simply not tolerate it as well. Okay? When you get beyond, the only other thing I want to say about sexual harassment before I show you a couple things is you can get beyond the male-female norm. When we talk about sexual harassment, it is generally male-female, okay? You can have female-male, where the female is the harasser. Usually it is the male. The cases that we see are generally where the male is the harasser. However, you can have male versus male harassment, or female versus female harassment, if it is based on sex. Now, don't confuse that with gender preference, because gender preference is not protected under Title VII, okay? So if somebody wants to terminate somebody because they have a different sexual preference, most employers can do that. However, where you have a male supervisor or an employer who allows a male coworker to harass another male because of their sex, that can be a violation of Title VII. So if you have a male supervisor who also happens to be, for lack of a better term, a homosexual, who is harassing another male because he is male, okay, and sexually attracted to him or whatever, that can be discrimination under Title VII. Okay? Everybody see the distinction there? Now, some states, some companies, this university prohibits discrimination based on sexual orientation. Title VII does not. Okay? Here, as you look to see whether it's sexual discrimination or not, just some questions that you may want to ask, and probably wouldn't hurt to put in policies if you ever have to write a policy, is would you engage in this behavior if your significant other were around? Okay. So if you're doing the barking or the grunting, okay, would you do that? And I'm not saying would you do that if you're to your significant other. Would you do that to a third person if your significant other were around? Okay. Would you want your significant other, sibling, child subjected to this behavior? And if you wouldn't, you probably ought not to be subjecting people. Okay. Would you want your behavior filmed and shown on the evening news? And if not, then it may be. Okay. And does the recipient of your behavior initiate the same way that you do? Okay. Or the same behavior. All right. Any questions? Any questions on that? All right. I want to show you the one area where sexual harassment has started coming, it's getting a little more controversial, if you will, or an area where it's getting a little more controversial, is in the area of when it competes with another right. All right, and what I mean by that is we see the area of art and sexual harassment sometimes competing with each other, okay? So let's see if I can, by the way, I have a couple of pictures that some of you may or may not find or may find offensive, all right? Try not, I hope not. If you do, I'm about to show them. So let me say, look, Dan, you don't have to raise your hand and say, I'm the one that's going to be offended by that. But you might actually pretend to be writing notes and acting like you really care or something. I don't know. But I'm getting ready if I can. And all right. Les Plains, you see a blank screen?
Yes.
You still see a blank screen?
Yes.
All right. Let's see if I can get this. And now, you know, when you say you're going to do something, everybody's like, oh, I want to see that, you know. I don't. All right. Can you see that picture?
Yeah.
And how come Springfield can't see it? Let's try this. There. All right. Is that the wrong way? There we go. All right. Now, again, don't look if you're offended. Sexual harassment or not?
Depends on if the person in the picture gave consent or not.
Well, yeah, I guess, Tom. If that person in the picture doesn't give consent, I think as a defense attorney, I could probably argue that person shouldn't be sitting there that long. But you're right. I guess I could take a picture of somebody and then imagine what I would do. Yeah, no, I think that's a good point. The more I think about it, that's a very good point. I could go home, paint a picture, and go, look what I did last night, you know. Yeah, so in that particular case. But let's say that painting is hanging up in the workplace. And somebody comes to you and says, sexual harassment. Do you take it down? Probably you do. Maybe you do. And part of that is because of why is it up there? I mean, you know, if you have it up there just because it's up there, Okay. What's the nature of the business? All right.
That's not going to be appropriate for most businesses.
It's not going to be appropriate for most businesses. What if you're in an art museum?
It'd be appropriate then.
Probably would be inappropriate then. This was actually a picture out of, and it may have been an art museum. Actually, it may have been an art museum, a city museum, out of Murfreesboro, which is right near Nashville. Okay, an interesting case because it was really just the reverse. Employee files charge of discrimination, or actually says before they get to the charge stage, says this picture offends me. Okay, and we want you to take it down. Maybe it's in a prosecutor's office. Prosecutor brought it down or said it should come down. Okay, they took it down. Murfreesboro then got sued. The city of Murfreesboro, because it was a city that was doing it, got sued. You know who they got sued by? The painter or the artist, claiming what? Huh?
That it's art?
Yeah, but why would the artist sue?
Advertisement for them?
Pardon?
Just something maybe they paid him.
Okay.
He couldn't make money,
Couldn't make money. Really, it's a violation. They argue that it was a violation of their free speech. Okay? And the court actually said, you know what? We're not going to address the sexual harassment because that's not before us. But for a city to require this to come down is maybe a violation of free speech, and hey, you got to put it back. This was interesting. Now, what happens there, when you look at that, that's different than, and Lisa, was it you or Whitney? Who said take it down? Lisa. When you say take it down, many private employers probably would take it down and would be okay, because private employers, keep in mind, private employers can infringe upon free speech for the most part. Okay? The government can't infringe. Private employers aren't prohibited by the Constitution from infringing. So, it could take it down. Show you the second picture. Only because it's a real live. And you may not be able to is that upside down? All right. Can you see that well enough? So? I don't know that we can focus it. Okay. Basically, what does it appear to depict? Just so I can. Well, let's help a little. I don't have my laser. Nose at the top. Does that help? We see, let's go all, I can do that from here. We got eye, right? Nose, mouth, right? Okay. Sexual harassment.
Maybe because there's a hand there.
I mean, that looks more like,
Pardon?
Is that her breast?
That is her breast.
it looks more like a doll than a person.
Okay. Okay. And the reason I show you that is real life case going on right now. Okay. And sexual harassment or harassment offensive. And so the employer is going to have to decide, do they take it down or not. So when you get into there we go. West Plains, what are you seeing now? All right. When you get into this idea of management and sexual harassment, it may be more. You'll find a lot of people that are offended, particularly if they happen to be, not in any of these particular examples that I just showed you. I don't think that was the case at all. But a lot of times when people are getting ready to be disciplined for something else, they'll rush out. Sexual harassment may have occurred, okay, but frequently it is used as a defensive mechanism. So you got to be ready for all of that and how to handle it. And the best way to handle it is make sure you have proper policies and procedures in place. All right. Any questions about sexual harassment? Pregnancy Discrimination Act or sexual discrimination or gender discrimination. Okay. All right. Next week we will cover a lot of areas. We'll cover age, probably 11 through 14, and I know that's a lot in your book, but they're really that reading goes by pretty fast. At this point, you've got the basic understanding of the bona fide occupational qualifications, of the charges, of the things we talked about last week. We're just going to be very specific in looking at some age and religion. There'll be some interesting religion cases. We'll take a look at a couple of those, and then some disability stuff. All right. Anything else? All right. Have a good week.